Hello and thank you for joining us again for another episode of Kidnapped Hearts, the weekly TV show brought to you by the International Criminal Court against child kidnapping. We are committed to bringing you the ugly truth about the corrupted family court systems and heinous crimes against children, which the government continues to turn a blind eye to. In one of our previous episodes, Dark Secrets, advice on how to safeguard yourself and your kids from CPS, we gave you some inside information about interacting with CPS. If you haven't already seen that episode, then we strongly recommend that you do. This week, we'll be providing you with inside information about child sexual abuse, and if you're the protective parent, it's important you pay close attention to this episode. But before we go any further, as a disclaimer, we must stress that this episode is not about breaking the law or doing anything illegal. And even though not all officials are crooked, that doesn't mean that you should let your guard down. Nor are we lambasting the foster parents who open their homes to these children, as a lot of them are good people. Furthermore, whatever we say here should also not be viewed as legal advice. If in doubt, it's always recommended to speak to your lawyer. And if you do need legal help, you're welcome to contact our office, where we can give you further advice. In 1992, at a hearing on child sexual abuse in New York, Congressman Major R. Owen said, "Ignoring or mistreating child sexual abuse is tantamount to allowing an untreated cancer to grow in our society." This statement was made 26 years ago, yet that sad truth is that still applicable in this day and age, perhaps even more so. Here are some statistics that are equally as shocking as they are horrific. According to RAIIN, out of yearly 63,000 sexual abuse cases substantiated or found to have strong evidence, the perpetrator was most often the parent. 80% of perpetrators were a parent. 6% were other relatives. 5% were other, from siblings to strangers. 4% were unmarried partners of a parent. In 88% of those sexual abuse claims, the perpetrator is male. In 9% of cases, they are female, and 3% are unknown. The effects of child sexual abuse can be long-lasting and affect the victim's mental health. Victims are more likely than non-victims to experience the following mental health challenges. About 4 times more likely to develop symptoms of drug abuse. About 4 times more likely to experience PTSD as adults. About 3 times more likely to experience a major depressive episode as adults. Firstly, let us elaborate a little bit further about what a protective parent is. This is the parent who is trying to protect the child from abuse. And in this case, we're talking about sexual abuse. And yes, we are only too aware that there are some parents who make false allegations in divorce cases or custody battles to give themselves a dishonest advantage. We are not speaking about those immoral and deceitful parents. No, this episode is about those parents who genuinely find themselves in the situation where they have honest proof that the other parent had abused their child. Unfortunately, these protective parents also find themselves in the firing line of having to prove their cases, even when there's a mountain of evidence that the abuse had occurred. You would presume that if there is sufficient evidence of abuse, the court would surely award the child to the protective parent, right? So imagine what happens when the family court gets it completely wrong and gives custody to a parent who is the one who abused the child. Sounds insane. That's because it is. In the US, around 58,000 children are ordered by family courts to have unsupervised contact with parents who had abused them. Yes, you heard that right. And yes, it happens all the time. Where are the social services now then, you might ask, in cases where the child genuinely needs protecting? The CS Monitor reported on a case of a mother, Jonia Rogers, who found herself in the same situation. Consider the case of Jonia Rogers, a hairstylist from Marin County, California. During her costly divorce, she sought help from numerous law enforcement, child protection, and family court authorities to protect her daughter. From what medical evidence and reports by the child and her babysitter suggested could be ongoing neglect or sexual abuse, or both, by the girl's father or grandfather. None of the authorities she approached would effectively intervene to protect her daughter. So in 2000, Ms. Rogers eventually felt that she had no choice but to flee with her child to protect her. More than 3 years later, this protective mother was caught and jailed for 5 months, while her daughter was immediately handed over to her alleged abusers. Rogers faced criminal charges for violating a court order by fleeing with her child. After considering the evidence in her case, a jury of her peers completely exonerated her of all wrongdoing. The very same evidence that exonerated her in the criminal court had been called frivolous by the family court judge and disregarded. It's not uncommon for family court judges to award custody of the child to the abusive parent, despite evidence of recorded abuse, such as restraining orders, sexual abuse, domestic violence, addiction issues, alcoholism, child abuse, and dangerous behaviour. And in the midst of this, the protective parent is victimised for bringing the evidence of child abuse to court. Again, we stress that this is not about those unscrupulous parents who make up false allegations and go as low as to use their child like a pawn in messy divorce hearings. No, this is about the genuine parents who are wanting nothing more than to protect their child from genuine abuse that's taken place. So, what do you think the family courts do to these genuine parents? They accuse these parents of trying to alienate their child from the abusive parent. They're accused of fabricating the story and coaching their child to lie. And instead of focusing on investigating the evidence, the blame shifts to the protective parent who is fighting against sharing custody with someone who molested their child. It's rare that these cases go in front of a jury, and instead it's the family court judge who will get the final decision. And sadly, the protective parent and child find themselves in a position where they're seeking help and justice from a body who is not sufficiently trained or is simply apathetic to the aforementioned abuse. Again, take into account the percentage of children who lie about being abused is quite low. A report discovered that 98% of children who alleged that they were sexually abused were telling the truth. Marilee McLean was a Denver mother who noticed that a 2-year-old daughter started to exhibit and express behaviour consistent with sexual abuse. Yet when McLean reported her case to the courts, it would turn into a horror story, one that would cause her to lose custody of her daughter. And even though there were 3 police reports and 3 hospital reports that confirmed her daughter had been sexually abused, sole custody of the child was awarded to the abusive parent. She told her story in an article in Women's E-News. At the outset, I had full custody of my little girl and her father had limited visits twice a week. But after raising sexual abuse allegations against her father and spending 3 years in the family court trying to protect my daughter, I was reduced to 1 hour a week supervised visits for 8 years and treated as if I were a hardened criminal. This was all due to a custody evaluator's opinion through an ex parte, a hearing without all the parties present. The evaluator cited Dr. Richard Gardner's debunked parental alienation syndrome and left out all the medical reports, police reports and preschool teacher reports. The ordeal began the day I took my beautiful little girl Amy, freshly bathed with her dark hair in a high ponytail and wearing a pink dress, to her daycare centre. On the way, I imagined how her father would pick her up for his 3-hour visitation that afternoon. That evening, I went to his house to pick up Amy. I knocked and waited until he finally came to the door. He waved me in and said he would get Amy. As I waited, I noticed that Amy's beautiful clothes were strewn about the living room floor. When he brought her down, Amy was wet, nude, and limp in his arms. Her arms dangled at her sides, her ponytail was out of its band, and her hair was matted. She was soaked with sweat. My heart sank and my gut pulled tight. "What happened to her?" I asked him. He looked at me with a strange smirk. That may have been the first time he abused our daughter. And that terrible sight of him carrying her down the stairs limp in his arms would wake me out of sleep over and over, causing me to sit straight up in my bed, shocked and horrified. No words can express what it's like to realise your child is being sexually abused. My precious little girl would tell me and others about unimaginable things that were happening to her that made my heart feel like it was getting ripped out. But trying to stop the abuse was like fighting a hydra-headed monster. Each year, 58,500 children who seek protection from abuse throughout the US family courts are ordered into custody of a violent or sexually abusive parent. I had no indication of what was happening. I lost courtroom battle after courtroom battle. The more I fought the system, the more time the father got with my daughter. And this was in the face of physical evidence of his sexual abuse in doctor reports, hospital reports, police reports, and daycare provider and preschool teacher reports. All of these were either ignored or suppressed by the court. Worst of all, Amy, the child being abused, had no voice. My child was not heard. McLean's book, Prosecuted but Not Silenced, Courtroom Reform for Sexually Abused Children, talks about her 12-year fight with the family court, and it highlights the inept training and lack of qualifications of judges, social workers and therapists when it comes to handling sexual abuse cases that involve children. So, a child who has already been traumatised is again failed by a legal system that is simply too lazy and ill-equipped to protect them. Instead, these courts seem more interested in removing children from loving, caring family homes for the benefit of financial gain, as we've revealed time and time again in our series. And of course, no one in the system is ever accountable for making wrong decisions or ruining these children's lives. The judge is often favourable to a parent who is deemed to be encouraging of the child seeing the other parent. But of course, which parent in their right mind would want their child spending any length of time, especially alone, with someone who sexually abused them? So, another struggle a protective parent faces is that they may be frowned down on if it appears that they're speaking ill of their ex-partner, and therefore will be in danger of being seen as alienating the child. This is known as parental alienation syndrome, or PAS. Ironically, one of the factors that proves this parental alienation, according to the family court, is where the child has expressed dislike or fear of the other parent. And as such, the child then stated that they did not want to see that parent. To the average person, this may seem like a very normal and understandable reaction for a child who has said that someone sexually abused him or her. But of course, by now we know that the system works in a way that is anything but normal. Judges and lawyers use PAS as a way of saying that both parents should have involvement in the child's life, despite the fact that there may be evidence that implies that one parent abused the child. It's even known that there are judges, lawyers and psychologists who are willing to accept bribes to sway the decisions in favour of the perpetrator. Furthermore, whilst the case is pending, the court can issue an order for the abusive parent to have access to visit the already traumatised child. And in some cases, those visits are unsupervised. And if the protective parent does anything to obstruct the child from seeing the perpetrator, then they can lose the custody altogether to the abuser. It is hell, and sadly, the one who will be burnt the most in that pit of fire is the child. One child whose life turned into a living horror story was Damon Moulter. He was 6 years old when he first said that his father had been sexually abusing him. The courts, however, were unwilling to believe him, despite all the evidence, and as such, gave his father sole custody of him. Damon eventually fled and went into hiding, and started to post videos online in protest against the family court for failing to protect him. At 16 years old, in desperation, he got married, since it was the only way he could attain legal emancipation from his father. East County magazine reported on the case, saying, "Although his father was never convicted, Damon's experience has prompted legislation in Sacramento aimed at protecting other children in similar situations." The Moulters got divorced, and afterwards the case was transferred to the downtown San Diego court, which awarded the father custody, and he was never convicted of molestation. Oddly enough, Damon Moulter also said that a family reunification therapist, Dr. Barrett, approved his father's custody. Damon later ran away, going into hiding to avoid being sent back to his father. Fox News reported that Damon Moulter had to leave California and get married in Nevada when he turned 16 without his father's consent, in order to get away from his father's custody and become a legally emancipated adult. Damon Moulter stated the teenage wedding was a marriage of convenience for both parties, and he's now divorced and living with his mother, Cindy Dumas. Since there's such a massive silent epidemic of child sexual abuse, a new law called Damon's Law is being presented in the California state capitol to prevent this tragedy. The article also went on to interview former East County Judge Deanne Salcido, who said that she issued a writ against her supervising judge who told her not to follow the law because it was making the attorneys' lives too difficult. She said that she was not physically threatened, but the supervising judge made her life so difficult that she didn't want to be a judge anymore in the family court. She, Salcido, observed that if judges don't make attorneys happy, they will either be challenged in an election, or when judges retire, they won't be given the opportunity to be on private arbitration panels, because the attorneys won't like them and won't want to take cases to them. Salcido explained that judicial corruption comes not usually as a cash payoff, but sometimes a judge will agree to a certain ruling just to keep his or her job, or to plan for a post-judicial career as a $2,500 a day private mediator on family law cases. Salcido indicated that if you weren't pleasant and accommodating while you were on the bench, these opportunities will not be available to you. She stated that we really need laws preventing rulings on a Friday. With judges retiring over the weekend, going on vacation and opening up shop after advertising that they're for hire in legal newspapers as a family court mediator on these arbitration panels that are only for the wealthy. She spoke about two different tiers of justice: private arbitration panels for the wealthy, and everybody else has a family court judge and has to air their dirty laundry out in public. She also suggested that prosecutors are afraid of these cases because they're hard to prove, since most of them lack physical evidence and they affect their win records. Like adult rape victims on the stand, children are put through a lot to prove their case, she noted, since nobody comes out and says, "Yeah, you're right, I molested the kid." Compounding the problem is that the defence is trained to use the timing of the disclosure against the parent that mentions abuse. She stated that children won't usually tell about the abuse until they know the relationship is over and the parents are in court, which weakens the legal case against the abuser. Salcido believes that juries should be deciding abuse cases, not judges. Custody being awarded to a mother or father guilty of abusing their child is so categorically wrong. Yet this continues to happen every day right here in the USA. And as usual, the ones who are the real victims are the children. I encourage you to share this video with your friends and family. This is something that can affect parents and children everywhere, and we need to join in standing up against these injustices and to raise awareness. That's all we have time for today on our show. Thank you for joining us again for another episode of Kidnapped Hearts. Tell us what you think on our Facebook page at facebook.com/childabductioncourt.org or on our Twitter page at childabductionc. You can also drop us a line at our website, childabductioncourt.eu, or in the comments section below this video. Be sure to tune in next week for another hard-hitting episode with nothing but the facts.